Thank you, everybody, for joining KSAND for our webinar with Mark Rifkin with the Academy's PIA office. Mark Rifkin is the Academy's manager for consumer protection and regulation. He is highly engaged in the Academy's licensure and scope of practice work, including maintaining the online maps for licensure and therapeutic diet order authority, as well as working on the licensure compact incident reporting tool and with individual affiliates on their legislative initiatives to advance licensure. A second career dietitian since 2005, Mark was previously employed in private practice, as well as in a federally qualified health center counseling members of underserved communities in Baltimore. Outside of the licensure and regulatory context, Mark is passionate about plant-based diets and sustainability. Mark, thank you so much.
Thank you, Becky, and I'd like to thank the Kansas Academy for all of your patience while we get this scheduled. Apologies that the date still says June. That's when it was originally scheduled. And then June became September, and here we are. So moving forward. So our objectives. We'll look at your Licensing Act, steps and cautions to amend it, the IRT, also include some provisions of the MPA, and the process to implement the recently passed HB 2066. So the Licensing Act licenses the practice of dietetics. Only a person licensed or otherwise authorized to practice shall practice. And then we have the link. So everybody should be familiar with your statute page, what it looks like, where to go, how to find it. Of course, I'll be sending out the slides afterward. And the key provisions, of course, are 5903 and then 5902. So 5903 is what we call the exclusivity clause. And that's what 5903 says. Only a person licensed or otherwise authorized to practice shall practice dietetics. Notice that it never really defines or applies the term medical nutrition therapy. But it defines it using other terms such as nutrition assessment and other terms we see down here. So specifically establishing priorities, goals, objectives, and then recommending appropriate nutritional intake, including enteral and parenteral nutrition. So even though we generally, obviously, we recommend that states include the words medical nutrition therapy, your law was written before that practice came into place. And most states, of course, define the meaning of certain activities in the first part of statute, and they follow up with establishing what that means. So in some sense, your law is fairly conventional in that sense. Then you have exemptions. Under general direction, somebody can practice, or someone who is working in non-medical nutrition. Generally meaning provision of nutrition advice to those who do not have a diagnosis. Notice most local, state, and federal employees are exempt. Serving in the military, those providing info about food in a health food store context, and those providing weight control services under general direction. So as we go through this, these are all provisions that we're looking to standardize between states. Right now, what we basically have is 27 states that require a license to practice, each of which has their own set of definitions, set of exemptions. If you have cats, it's like herding 27 cats. So the way we standardize most of this is through our Model Practice Act, which is our model for state licensure legislation. So, of course, this postdates your law. Excuse me. So the MPA was developed by member experts and staff. It sets a standard for academy licensure policy. It's updated as issues and solutions arise. Of course, it's approved by the Academy Board of Directors. And it is public facing. In other words, we presume that everything we write more or less is going to get out, quote unquote. So, including this. So through the MPA, if we can establish consistent sets of standards between states, that facilitates a compact. So the language in the MPA is fairly detailed. It's specific for boards and legislators. Of course, it goes into what I'm labeling here as the 3 E's: education, experience, and exam. The goal, of course, is to reduce ambiguity and increase clarity, to set high standards, but also to allow states to have that flexibility that they sometimes look for. Every state likes to do things certain ways. They like to write it this way, not that way. It also provides rationales for content in simple terms. And in a sense, all the pieces fit together like a whole. So perhaps the key provision of our current Model Practice Act that many members find most interesting is we have what we call a 2-tier license model. One for a tier for a licensed dietitian nutritionist, and another tier for a licensed nutritionist. The difference between being the inclusion or exclusion of food service, enteral and parenteral. So in states that have this, essentially what they're doing is they're issuing they're offering 2 licenses. So if you're an RDN, of course, you automatically meet the requirements for an LDN, licensed dietitian nutritionist. But legislators really don't want to see their law automatically and categorically tied to a single third-party standard. They want to allow another pathway, and that's what the licensed nutritionist is. So it essentially allows select qualified others, such as CNSs, to get a license with a smaller scope. And generally speaking, that smaller scope excludes enteral and parenteral and food service. So many of you may be familiar with CNSs. 5 years ago or so, the CNSs were our traditional opponents. If we said up, they would have said down. And quite literally, they did. Not for any reason other than the fact that we set up. And in fact, in Maryland, where I'm from, there was a bill in our legislature in 2015, I believe, that would have codified the right of the board to do certain things. And keep in mind that CNSs are eligible for a license in Maryland. And the CNS has opposed the bill. Why? Well, solely because we supported it. So I called the lady on the phone and I asked, do you really know what the bill says? And once I explained it to her, she said, maybe we should take another look at this. That's literally how the conversation went. So, so the CNSs were the traditional mouthpiece for licensure opponents. But since we've offered them an opportunity to come into the fold of licensure and credibility, that's probably the single biggest reason why we have a law that was passed in New Jersey as of a year and a half ago. It's because we converted the primary opponent into a partner. And I believe why we will have, what I'm hoping to have is reasonably good prospects for success in Wisconsin, Michigan, and Pennsylvania, because we converted an opponent into a partner. So of course, the other thing the MPA does is it reduces the wide variety of qualifications in education, experience, and exam, and of course codifies authority for telehealth and therapeutic diet orders. I can't remember what Kansas's status for therapeutic diet order or something tells me it's yellow, which means there's probably some sort of conflict. But in many states, the only way we're going to be able to facilitate dietitians or ordering therapeutic diets is we have to pass a law to do it. Okay. So for affiliates, so the MPA provides, again, that clarity and consistency in statutes between states, facilitates interstate practice. And of course, it provides what is a key defense against the often repeated claim that the academy goal is nothing more than monopoly. Well, it's hard to make that case when you specifically allow for a CNS credential to be eligible for consideration for a license. And of course, it clarifies essential provisions versus those that are only desirable. So as I mentioned, it was passed in New Jersey. New Jersey was trying to get licensure for 30 years. They never really got it. If I'm not mistaken, they never got it out of committee. As soon as we applied a new model of partnership, the law passed quite easily, in fact. We've also upgraded our existing statute in in North Carolina and North Dakota. So everybody hopefully knows Pepin, my colleague, the attorney. So following 3 key principles, which is a solution is nearly always possible. Maybe that's not been traditionally the approach that we've taken in years past, but the goal is to see how we can work together with opponents as opposed to just fight like cats and dogs. And legislators really don't want to see that. And if we truly seek to understand their needs and their motivations, then ultimately we can all walk away pretty much satisfied. And we don't give up anything. That's our core set of principles. More importantly, they seem to enjoy the fact that they got something out of what they think is the academy. in other words, in Florida, you may have heard that there was a bill that would have essentially converted our licensure law into a Title Protection Act only. And it turns out all they really wanted was weight loss. And Pepin said, okay, let's say we'll loosen some of the restrictions on weight loss. We literally came within about 2 inches of losing the entire law. And Pepin offered his compromise. Everybody walked away happy, and the law is fundamentally intact. So we had a similar scenario recently in Missouri as well. The IRT, hopefully most of you are familiar with this by now, but IRT stands for Incident Reporting Tool. It's basically a way for the Academy to start compiling harm reports as well as success reports. So this is designed to compensate for the gap in collection and sharing of stories. So as we move through additional challenges to licensure, both in the courts as well as in legislatures, they're going to want to know, okay, if you want licensure, then you have to document the benefit. How do we document the benefit? Well, hopefully the board is collecting harm reports, but let's say you're in a state that doesn't license the practice, which, again, only half the country does. So, so this allows us to build a database of evidence that dietetics really is something more than Googling fruits and vegetables. It's a little bit more complex than that. And of course, the opponents always want to minimize the complexity and essentially conclude that what you guys talk about is fruits and vegetables anyway, and I can Google that. So why should we license the practice of dietetics? So the IRT is, of course, it's not intended to replace a valid state reporting method, such as, in your case, KDADS. It's also not intended to protect RDN jobs from competition, but it is intended to sort of enhance the ethical self-regulation of the profession. So I'm hopeful that with good application of the IRT, we're going to start to collect some valid reports of harm. I think what we are starting to see already is, particularly with the impacts of COVID, is dietitians who are seeing patients with eating disorders. And of course, for any of a number of reasons, something changes about the licensure status of the state in which the patient lives. And unfortunately, these patients, so I'm sure they are extremely vulnerable, both psychologically and physically. And we've already had some cases of dietitians who've had to abate the harm caused by some health coach, simply because they didn't know that the health coach didn't know what they were doing with a patient with an eating disorder. So that's probably going to be one of our likely scenarios. Legislative relationships. So, excuse me. So of course, in any state legislature and any state capital, certain organizations have great legislative success. What exactly does that mean? That means they have relationships with certain legislators. That means if constituent A wants to get the attention of legislator B, if they have a good relationship, all that constituent needs to do is pick up the phone literally, and talk to legislator B, and they automatically have their attention. That's ultimately what you're after when you're building relationships. It's maybe in years past, it could have been simple enough to rely upon an email, but no more. And in my own personal policy history, I went out to meet a legislator who wasn't even mine. This is about 15 years ago. But I liked what he said about prevention, and I went out to meet him. And the next thing you know, he asked me to volunteer for his campaign. I didn't even know the guy from Adam. He didn't know me. And I think I volunteered for his campaign for maybe 6 hours or something. 10 years later, he still knew my name. When we went to our state capitol, he wants to know, where's Mark? And why isn't Mark coming by my office? Because I want to see Mark. Maybe that's a little extreme, but that's sort of what you're after. You want to be on a first name basis with one or more of your legislators, so that they can rely on you and you can rely on them. So if there is in fact a legislative issue that needs their attention, you are more than just an email address. So relationships, of course, are built on know-like trust. Personal time, the in-person visits, of course, talking pre-COVID. Currently, video calls seem to be an essential tool. But, and those relationships don't happen, they can't be created during a legislative session. They have to be built upon and the foundation laid way before you reach a legislative session, which is ultimately, you might say, now. So it'll take time to build a good, solid relationship with a legislator, but ultimately, you want to be on that first name basis. Which legislators? So generally, you're looking at House leadership, majority leaders in each House, committee members. So of course, any bill that gets considered is going to be referred to any of several committees. Generally speaking, that committee chair has a lot of leeway in determining whether or not that bill gets heard. And ultimately, the committee chair is beholden to their boss, or bosses, you might say, which are the majority leaders and the House and Senate leadership. So ultimately, you want to know the committee chair. Yeah, it's also good to know the committee members as well, but the committee chair has a lot of leeway over whether or not your bill even gets heard, or if the bill is, never heard, shall we say. (2066). So this is was of course recently passed by the Kansas legislature. It's what we're calling a universal recognition law. The original intent, or at least the cover, was military and spouses. A lot of states are trying to facilitate active practice by military and spouses. So of course, as I'm sure you know, these people are moving around a lot. It would be kind of a pain for them to apply for a license in every state that they move to, and then they pick up and move 6 months later, and et cetera, et cetera. So But essentially what it came down to is the law was written to allow the Kansas licensing body to issue a license to anyone who holds a similar credential from another state with what is supposed to be a similar scope of practice and supposed to be equivalent to that held in Kansas. So in theory, but of course we're concerned that this basically is a means to undermine the fundamentals of licensure. Note also that they have probationary credentialing, which means somebody who worked in a state without a license under private certification, for example, California, which doesn't license dietetics at all. Well, let's say they're a health coach. They've been working there for 3 years. Now they want to move to Kansas. They want to get a license. Under this provision, they can be credentialed on a probationary basis. So they can essentially get a dietetics license. So obviously we have major concerns about that. Then there's also temporary provisions as well. And of course, both the temporary and the probationary can, in theory, become permanent licenses. So essentially, your state is one of 16 states that have one of these universal recognition laws. It's part of the process to whittle away at licensure. Since they couldn't defeat it through the front door, they're whittling away at licensure through the back door. So we are working with outside counsel to do a thorough analysis of this. But ultimately, again, you're one of 16 states. And we are obviously a little bit concerned about how this is going to go down the road. So 2066, the next steps. So fundamentally, the agency, in this case, KDADS, is going to issue a written regulatory proposal. That's going to be published in the Kansas Register, which I've linked here. So they're basically going to write a regulation and say, this is what we think. They're probably going to have a hearing, perhaps more than one, theoretically with testimony. And they're going to issue another revised proposal, perhaps 2 or 3 revisions. And then at some point, they're going to finalize it and say, okay, we've heard all the voices. We've made some amendments. Here is our formalized, finished regulation. So essentially, passing a law is really sort of the first part of the battle. It's not nearly the entire battle at all. So in some sense, we can still modify we can't modify the provisions of the law, but we can modify how it's implemented. And that's where you're going to want to know, just like you wanted to know, you wanted to have relationships with your legislators. You also want to have relationships with people in KDADS. So, and I understand one or more of your colleagues has been working pretty well with KDADS on this. But you never want to sort of rest on your laurels. Because ultimately, they're not necessarily obligated to listen to any one party. They may be obligated to read what you say, but they're not obligated to agree with it. So of course, and at some point they'll they'll issue a formal regulation in the Kansas Register. So real quickly, a summary. Know your law and where to find it. How the process that could be affected to change that law and how to amend it. Continue to cultivate those legislative friends and champions. And don't blink. Literally, don't blink. Because stuff will pass you by. And then before you know it, how did they pass that law? Exactly. Questions? Becky, are we ready for some questions?
Yeah, if you have questions, go ahead and unmute, or you can use the chat function at the bottom of the screen and ask any questions that way. Okay, so we do have one question here. Does it make a difference that our statute states that you must be an RD from CDR?
Well, yes and no. So fundamentally, basically what this means is any RDN is automatically eligible to be an LDN. In other words, a registered dietitian is automatically eligible to become licensed. But as we move through and standardize the Model Practice Act in states, which of course, we haven't started working on the Kansas laws yet, but fundamentally, it doesn't really change the status of yourself and your colleagues. But the longer it goes, potentially it could provide ammunition for those claiming that the academy is just creating a monopoly. So ultimately, again, we'd want to see that changed and implement that two-tier structure with a CNS or basically allowing for CNS eligibility.
Okay, Mark, one other question. As you consider the Kansas law, which specific would you recommend needs to be changed? Are there some elements of the Model Practice Act optional for our state?
Well, in your case, your law is, shall we say, not that new. So we're basically looking at a fundamental rewrite, more or less. So your law, as it currently stands, it's fairly simple. It's fairly short. The Model Practice Act is, shall we say, much longer. So for example, obviously we codified the definition of medical nutrition therapy and what that means. That's number one. One of our current concerns is supervision. So in other words, who is supervising an intern? And are they themselves eligible for a license? Do they have a license in good standing? And are they essentially, do they meet the qualifications that the licensee or that the intern is hoping to apply for or apply under? So in other words, it probably wouldn't make sense if the supervisor does not themselves meet the eligibility requirements for a license when the intern is seeking to apply basically under those provisions. So that's one of the things, and one of the other things that we're looking to standardize is supervision. And not only for interns and students, but also, you know, for example, NDTRs who may be working under supervision, and how we're gonna accommodate four-year graduates in the new license, in the new, excuse me, licensure structure under the graduate degree requirements. So, so ultimately, we were going to have to arrange for some sort of legitimate supervision of people who can, in theory, provide MNT, but only under that supervision.
Okay, I have one more question. Are we at risk of losing our current privileges when our licensure is renewed?
Well, technically not currently. So when you say your licensure is renewed, in other words, a license coming up for renewal is not an opportunity to rescind it. You can only lose a licensure structure by law. So in other words, literally, Kansas legislature would have to pass a law essentially repealing the existing provisions of the existing law. As you individually come up for a renewal, that's not a means by which they can take away your license. But of course, anytime, I mean, somebody can introduce, well, somebody could be writing a bill right now, literally, that would be, introduced come January, that would theoretically repeal. So ultimately, any licensure law is potentially vulnerable at any time. And that's where those relationships are going to be essential. So, for example, we had a similar situation in Ohio just recently, if I can recall some of the detail. But ultimately, the Ohio board decided to do some things. Oh, actually, I remember. The legislator tried to go in again via the back door. Instead of writing a bill to actually repeal the law, he attached basically an amendment to a budget bill. And the amendment was basically said, we hereby repeal the licensure law for dietetics. It was extremely underhanded. And it nearly worked, nearly. Fortunately, the Board of Medicine of Ohio, under which sits the dietetics structure, they found out, the lobbyist for the Ohio affiliate found out, and that that provision was essentially killed outright. But it demonstrates again that, potentially we are vulnerable at any time to attack. And it's not necessarily going to be through the front door, so to speak. Again, what they can't accomplish through the front, they're going to try to accomplish through the back door. And you got to hand it to somebody who, attaches a bill to repeal an entire licensure law by attaching something to a budget. I mean, it just doesn't get any more underhanded than that. But that's where, again, having those legislative relationships, in this case, a lobbyist, that's what you want. That's essentially what you pay a lobbyist for, is to watch your back. Because there's going to be people out there who they're scheming right now. How do we kill off the darn dietitian licensure law? So, and even if you're, even if you have really great relationships, of course, those relationships potentially change every 4 years, every time you have an election. So if you're great relationship with Legislator Smith, well, Legislator Smith didn't win his election or her election. Now you've got to start over. And of course, even if Smith wins their election, they're also getting lobbied by opponents as well. So that's where, you never want to rest on your laurels. But technically the law, I wouldn't say is at any immediate danger, but that's where building those relationships is so key. So, even if somebody does come in with a proposal that, having that relationship with somebody is going to give you a heads up way before that heads up is critical. You don't want to be, 3/4 of the way through the session to find out, whoops, there's a bill here to repeal our whole licensure structure. That's not the time to find out. Time to find out is way ahead of time.
Okay, another question here. Is there concern that the Kansas legislature is wanting to repeal the licensure law? Or is the concern because of the danger that they will take that action if we ask to have it updated to include the medical nutrition definition?
Good question. So, again, I don't see any specific threat from the legislature at this point. But having those relationships and essentially going through a revision process with a legislative champion and their aide or a lobbyist, essentially, you might say all the legwork is done even before the bill even sees a vote. So I don't remember if we've been working with the state of Michigan for well over a year, it seems, writing a law, then rewriting it, and then writing it again, and let's revise this, and then let's revise that. And that's ultimately some of the extensive negotiation that's involved in a bill, is it literally will take a year or more. But essentially, you want to get the bill so well refined, so well written that any concerns are addressed, and that it basically the vote is more or less a done deal because you've already addressed the concerns of the opponents. So the vote becomes more or less a formality. You already know how it's going to come out because you've already been working with legislators through the whole year to be sure that your bill meets their concerns. You know, ultimately, you don't want a vote to be a surprise. You want to have 99.9% of your ducks in a row.
Okay, next question. What are your thoughts of a requirement of a master's? Will it help? And does the requirement of the master's need to be specified in the law?
Good question. Yes. So that's the other thing that the MPA is designed to do is essentially to take away any specific provision for a bachelor's degree and basically just tie the primary means of eligibility for a license to an RDN credential. So in theory, if, you know, in 10 years or 20 years, a PhD is required, we won't have to go back and amend the law again. The standard will simply float, so to speak. So if it becomes a PhD, then it's already covered because we basically said if you're an RDN, you're eligible, period. Unfortunately, a lot of state laws currently say a bachelor's degree is required. And yeah, that does present some concerns in some states. There was another part to that question. Can you repeat that, please?
Yes. Is the concern, let me see, sorry. What are your thoughts of the requirement of a master's? Will it help? And does the requirement of a master's need to be specified in the law?
Well, I guess it all depends on your definition of help. Keeping in mind that technically licensure is not designed to, you know, it's not designed to protect us from competition, but in my opinion, you know, it's tough to make a case that we are healthcare providers with a bachelor's degree. If we want to be considered to be a competent and equal player at the proverbial clinical care table, I think a master's degree is the only way to go. You know, how we get around that from a salary standpoint, from a legal standpoint, obviously we're basically looking at modifying almost every state statute to accommodate the master's requirement. Salary wise, well, honestly, I wish I had a really simple answer that everybody's salary is going to go up by 15%. Well, as of January 1st, 24. Unfortunately, that's not up to me, but we understand the concerns of many members who are wondering how they're going to, you know, how they expected to pay additional expenses associated with a master's degree when they're still earning $40,000 a year as a clinical dietitian. Yeah, that's a legitimate question. Ultimately, there's excuse me, multiple things that need to be done to elevate the profession to advance our salary on a broad scale. I think a master's degree is certainly going to be part of that, but there are other things too. But we're not going to be regarded as equal players at the table without a master's degree. But again, ultimately, we're we're basically looking at amending every state statute to accommodate the graduate requirements so that when it does come to pass, or when it is implemented in 24, that we are not behind the 8 ball, so to speak.
Okay, another question. We are a Republican state, so realistically, we need to develop relationships with Republican leaders, even though we're a nonprofit organization. Is this correct?
Yep. So the Academy is always nonpartisan. In fact, generally speaking, on a national level, we tend to give more to the Republicans than Democrats. And that's going to be true here as well. We may or may not have a lot of common ground on a lot of issues with Republican legislators, but ultimately that's the nature of politics. No two people are ever going to agree on 100%. But the nature of politics is helping somebody else. Let me see if I remember how to say this. Helping somebody else see their way through your eyes. In other words, convincing them the wisdom of your perspective through means that they understand. And that's that's fundamentally the nature of politics.
Okay, we've got just a couple of minutes left. Any last questions? No? Okay, well, thank you so much for your help, Mark, and thank you for your expertise in this, and we appreciate you going through with us all of the ins and outs of this topic. If anybody out there has any questions, feel free to email Mark. His email address was on the screen, or if you would like to email me, I can pass that along either to our local advocacy team or to Mark.
And thank you, Becky, and the rest of Kansas group. My gratitude to the rest of the Kansas affiliate for your patience while we worked on this. Apologies for my coughing. I'm getting over COVID.
All right, thanks so much for coming, everybody.